AMV Holmes. I love his case. Pretty recent, last year. And as I appreciate it, the majority opinion was kind of tough to get through. It was like 95 or 100 pages, but 13-year-old kid, 7th grader. He's fake burping in class.
He is.
And he's pretty good at it.
He's very good at it, apparently.
He disrupts the whole class.
He
so
does.
The teacher takes him out, sits him down in the hall, calls the assistant principal. She calls the police officer, I guess, assigned to the school. They take him to the principal's office, and the police officer arrests him. And kid's mom sues. I think it was a 1983 action, if I recall.
That's right.
His mom sues, and the majority held qualified immunity. And this is the way you describe the case. If a 7th grader starts trading fake burps for laughs in gym class, what's a teacher to do? Order extra laps, detention, a trip to the principal's office? Maybe. But then again, maybe that's too old school. Maybe today you call a police officer. And maybe today the officer decides that instead of just escorting the now compliant 13-year-old to the principal's office, an arrest would be a better idea. So out come the handcuffs and off goes the child to juvenile detention. My colleagues, the majority, suggest the law permits exactly this option, and they offer 94 pages explaining why they think that's so. Respectfully, I remain unpersuaded. But it's your last paragraph in that opinion that made me think of Trans Am. You went on to explain why you interpreted the statute to be contrary to the majority opinion. But this is how you wrapped it up. Often enough, the law can be a ass, a idiot, quoting Dickens and Oliver Twist. And there's little we judges can do about it. For it is or should be emphatically our job to apply, not rewrite the law enacted by the people's representatives. Indeed, a judge who likes every result he reaches is very likely a bad judge, reaching for results he prefers rather than those the law compels. So it is I admire my colleagues today, for no doubt they reach a result they dislike but believe the law demands. And in that I see the best of our profession and much to admire. It's only that, in this particular case, I don't believe the law happens to be quite as much of an ass as they do. And I respectfully dissent. How you doing, Judge?
I'm great. How about yourself?
You're that close to being done. That close. I think you've done pretty well today. I just want to go on record as saying this is an important nomination. And I appreciate all the questions asked today, even the ones I disagree with. I didn't know what to expect. I mean, this thing could have turned into the Gong Show real easily. It didn't. And I appreciate that. I want to ask you a couple of questions, some things that maybe we didn't get to talk about much. First, why have you recused yourself in almost 1,000 cases?
Well, Senator, in the 10th Circuit, we have procedures. Mm-hmm. And one of the procedures is we make a list of all potential recusal possibilities. And for me, it was significant because I had been in the government at a position where we oversaw a number of different litigating units. That causes a fair amount of recusal right there. And, Senator, I was blessed with an active and robust practice and partners who went on to do much better without me than they did with me. And they had a lot of clients. And it was my view as a circuit judge that I didn't want to cause an unnecessary recusal problem later. Sometimes after a court decides a case, a recusal issue pops up. Judges miss things. We're human. It happens. The problem when that happens, of course, is then you have to get a new judge in and start everything all over again. That's a cost to the system that's not insignificant to your colleagues and taxing on them. And it also raises questions, of course, to the parties who have to start all that over and cost them money and time. And I did not want to create that kind of problem for the litigants and for my colleagues. And so I set up a process consistent with the practice of my colleagues. I talked to my colleagues about how they do it and tried to conform to the practices of the 10th Circuit as best I could. And as you know, most of the recusals are not really, recusal is not even the right word, they're screened out by the clerk's office before they ever get to me. We're on a wheel.
Right.
And so I just get the next one on the wheel. Everybody gets the same workload. It doesn't affect our workload, but it does affect confidence in the judiciary. And
the recusal rules are different from the U.S. Supreme Court, as I appreciate it.
yes, Senator.
Okay. I want to ask you about the relationship between the United States Constitution and a state constitution and the interaction. And let me get specific so you'll understand what I'm talking about. I think this is well-settled law. A DWI, we call it DWI in Louisiana. Some states call it DUI, but a DWI roadblock. I think it's well-settled. A number of cases, U.S. Supreme Court, that says a DWI roadblock, so long as you use neutral criteria, is perfectly permissible under the Fourth Amendment. If I say anything wrong, stop me. It's clearly a seizure, but as long as you have neutral criteria. Do you remember why the Supreme Court made that decision?
I'm sure you're going to tell me, Senator.
Well, if you don't know, my understanding is that the Constitution only protects against unreasonable searches and seizures.
Right.
And the court balanced the public interest versus the extent of the privacy violation. But let's suppose, so that's well-settled law. You can, under the federal Constitution, you can have a DWI roadblock. Let's suppose the Supreme Court of Massachusetts, I wish Attorney Franken was here, said, we appreciate that, and we appreciate that's federal law, but we have a Fourth Amendment in the Massachusetts Constitution, and we want to go further, and we want to outlaw roadblocks. We want to give more protection. We don't want to take away protection that our citizens have under the United States Constitution, protection from government. We want to give them more protection from government and no roadblocks, period. Do you think that's permissible?
Senator, generally speaking, decisions based on independent and adequate state grounds are permissible. Mm-hmm. The primary precedent in this area is Michigan versus Long, a decision by Justice O'Connor. The state has to make clear that it's deciding on independent and adequate state grounds and not resting on the U.S. Constitution. If there's some ambiguity, we may, as federal judges, consider it to be a decision based on federal law. But a state is free to add to the liberties of the people, generally speaking.
Mm-hmm. Well, what if the adequate and independent state grounds aren't clear? What do you do?
Well, that's Michigan versus Long, and there's a precedent, and there's a test for it. Mm-hmm. And again, if it looks like it could have been on federal, the decision could have been made on federal grounds, then the federal court will examine it on that basis. State court makes clear that it's independent and adequate state grounds, well, then state law controls.
Do you think it makes sense? I mean, isn't the law complicated enough? Do we really need 50 rules for DWI roadblocks?
Well, Senator, that we have this thing called federalism.
I've heard of it.
Yeah, I figured you might. And it's part of our separation of powers. It's part of how we preserve liberty. Mm-hmm. Right? We diffuse power to protect liberty. And federalism is a key part of it.
Okay. I haven't read all your cases, but I haven't seen many where you dealt with substantive due process or equal protection. So I want to talk about that for a few minutes. If you have a case where you don't have a fundamental right or fundamental liberty, and you don't have a suspect classification, so you're not going to use strict scrutiny, you're going to use the rational basis test, which means you're going to uphold the statute if the legislature has a rational reason that's connected to a legitimate goal. How far do you go? How closely do you think federal judges should examine what the legislature does? Is it a rational reason? Is it any reason? Do you make up the reason for them? Have you ever heard of rational basis with bite?
I have, Senator. And before we get to that, I think it's important to acknowledge there's also intermediate scrutiny.
That's true.
For example, many gender cases.
For gender. But I'm talking about just plain old variety, no gender, no race, no kind of special heightened scrutiny, just rational basis.
The Supreme Court has indicated in what you're describing as rational basis with bite that sometimes if there's a discriminatory animus present, even though there might be a legitimate rational basis one could conjure for the rule, that might fail strict scrutiny, Senator.
Mm-hmm. What does the rational basis test mean to you?
Well, generally speaking, usually speaking, it means that if there's any rational reason that one can conjure for the rule, it stands out of deference to the legislative process.
Does it have to be a good reason?
It has to be a rational reason, not one that I find personally persuasive, but one that someone could find persuasive.
Okay.
That's out of deference to the lawmaking process of this body, Senator.
I understand. I want to ask you about the Trans Am case. It's been talked about a lot. You dissented. Pretty tough facts. Your dissent probably, I guess, made you about as popular as cholera.
Seems so.
Yeah. But as I understand it, you just looked at the statute. And tell me what the statute said again.
It said that an employee who refuses to operate a motor vehicle has certain legal protections from firing.
But he didn't refuse. He operated.
That's what I thought the facts suggested, Senator.
Mm-hmm. Well, I thought about that case when I was reading a case of yours that I commented on yesterday. AMV Holmes. I love his case. Pretty recent, last year. And as I appreciate it, the majority opinion was kind of tough to get through. It was like 95 or 100 pages, but 13-year-old kid, 7th grader. He's fake burping in class.
He is.
And he's pretty good at it.
He's very good at it, apparently.
He disrupts the whole class.
He
so
does.
The teacher takes him out, sits him down in the hall, calls the assistant principal. She calls the police officer, I guess, assigned to the school. They take him to the principal's office, and the police officer arrests him. And kid's mom sues. I think it was a 1983 action, if I recall.
That's right.
His mom sues. And the majority held qualified immunity. And this is the way you describe the case. If a seventh grader starts trading fake burps for laughs in gym class, what's a teacher to do? Order extra laps, detention, a trip to the principal's office? Maybe. But then again, maybe that's too old school. Maybe today you call a police officer. And maybe today the officer decides that instead of just escorting the now compliant 13-year-old to the principal's office, an arrest would be a better idea. So out come the handcuffs and off goes the child to juvenile detention. My colleagues, the majority, suggest the law permits exactly this option, and they offer 94 pages explaining why they think that's so. Respectfully, I remain unpersuaded. But it's your last paragraph in that opinion that made me think of Trans Am. You went on to explain why you interpreted the statute to be contrary to the majority opinion. But this is how you wrapped it up. Often enough, the law can be a ass, a idiot, quoting Dickens and Oliver Twist. And there's little we judges can do about it. For it is or should be emphatically our job to apply, not rewrite the law enacted by the people's representatives. Indeed, a judge who likes every result he reaches is very likely a bad judge, reaching for results he prefers rather than those the law compels. So it is I admire my colleagues today, for no doubt they reach a result they dislike but believe the law demands. And in that I see the best of our profession and much to admire. It's only that, in this particular case, I don't believe the law happens to be quite as much of a ass as they do, and I respectfully dissent. Is that what happened in Trans Am?
That's who I am, Senator.
Can you tell me something that you think is a good idea, but you think is unconstitutional?
Oh, Senator. It's been a long day.
I know.
But
and you're this close to CSI.
No,
okay?
no. Senator, I've loved every minute I've spent with you and with all of your colleagues. I'm sure I could conjure something.
All right, we'll think about it tonight.
But Senator, I wouldn't opine on it if I could. It's just not my job. It's just not my job. Is as you just read it. That's how I see my job. And I respect my colleagues who see it differently, because they did. They wrote a 94-page opinion in that case, a thoughtful one. And I respect them deeply. And the same thing in Trans Am. Right? Sometimes the law is what it is. And they see it one way. I'm sorry, Senator.
No, you go ahead.
No, we just do the best we can, day in and day out, in cases like these. And nobody hears about it. And it's the quiet work of judges trying to get it right.
And that's why I enjoy your opinions, aside from the fact that they're well written. You kind of play outside the pocket. I mean, you adhere to the written word, which is what I want to ask you about next. It's clear you don't like labels. Okay, you wouldn't call yourself an originalist.
Senator, I'm happy to embrace that. I don't reject it. I just am concerned about the level of our discourse in the society today, when we're often quick to dismiss one another, Republican, Democrat.
That's fair enough.
Whatever.
That's
not the world I care to inhabit. I care to inhabit an idea of respectful engagement of ideas with every person who comes before me. I do believe the original understanding of a text is very important to a judge, and I do believe any good judge wants to know that information, and I do.
And I believe the phrase you use is the original public understanding of the Constitution.
Yes, Senator.
What does that mean?
It means I'm not looking for hidden intentions, trying to get inside, respectfully, your head. Mm-hmm. I'm looking for the words you use, trying to understand what they mean, what a reasonable person at that time would have understood they mean. Because that's the fixed meaning I can latch on to and say, I'm enforcing that, not my will.
Is it the meaning of the drafters in 87,
No.
or is it the meaning of the legislators who approved the Constitution, or is it the meaning of the general meaning of the people? What if they didn't contemplate it?
Senator, they don't contemplate a lot of things that arise. Mm-hmm. Equal protection of the law, unreasonable search and seizure. These are broad terms, but we can give them content by looking to what the original understanding at the time was. Right? What a reasonable person would have understood them to mean. The fish case in the statutory construction scenario. What would a reasonable reader understand that to mean? And it serves a couple of important functions. First, it doesn't necessarily decide cases. It doesn't determine outcomes. And no one's looking to go back to horses and buggies.
I know that.
All right. What it does do is give us a way to communicate with one another that's neutral, that we're aiming at something outside ourselves as the basis for decision. That's part of the separation of powers. Not legislating, judging.
I get it.
Second, it's a due process concern.
I get it.
It's a fair notice concern. I can charge, I'm putting people in prison for long periods of time as a judge. I'm complicit in that. And I want to do it on a basis that I know that that person had fair notice of the laws that are applicable to him or her. That's important to me. And I think to all judges.
I don't mean to cut you off.
Oh, I'm sorry.
I just have to be mindful of the clock.
I'm sorry.
What's a penumbra?
Means not just the thing itself, but what surrounds it.
What's a legal penumbra?
Senator, that's a phrase that's been used in opinions by the court.
Do you believe there are unenumerated rights in our Constitution?
Senator, the Supreme Court interprets the Constitution, and that is a legitimate function of the United States Supreme Court. And in interpreting the Constitution, it necessarily declares in this case or that case, it sets a precedent as it interprets. I've come back to the GPS case because I think it's a wonderful example. Or Heller, it's another example. You can pick all sorts of examples where the court is interpreting a textual right in the Constitution or a statute.
Let me ask you about euthanasia. I didn't read your whole book,
I don't think many people have, Senator.
but I read enough about it, and I read a little bit of it. I believe you're an Episcopalian.
I attend an Episcopal church in Boulder with my family.
Yeah. I'm a Methodist. I was a Presbyterian, and Becky and I got married. She was Methodist. I was Presbyterian. We compromised, and I became a Methodist.
That's the way it works.
But as I understand your thesis about euthanasia, which you oppose, it's not really based on religious teachings. It's based on secular moral thinking. Tell me about that. That euthanasia, I mean, from one perspective, you know, if we have the right to control our bodies, if we have autonomy, privacy, and disclosure of privacy and all that, you know, this idea of self-determination. But you believe it can lead to something worse. Is that your thesis?
Well, Senator, this was in my capacity as a commentator before I became a judge.
Sure.
And as a student.
Right.
And when I was fortunate enough to get a scholarship to study law and a doctorate, I know you've spent some time thinking about similar things in a similar place. It struck me as an important and unresolved legal issue that deserves some thinking and a contribution where I could study and maybe add something to the discussion. Not that I have any great insights or perfect answers in this area. It's hard.
I don't think anybody does.
It's hard. I agree. I agree with that, Senator. And there, I expressed the belief that the conclusion as a commentator that the right to refuse treatment recognized in Cruzan by the United States Supreme Court was appropriate. Mm-hmm. People should be allowed to refuse treatment, go home, die in the arms of their family, rather than being poked and prodded. At the same time, I agreed with the Supreme Court as well that the right of question of assisted suicide was primarily a state responsibility. And that's where Glucksberg and Quill, the Supreme Court, has left the issue. Mm-hmm. And then the question becomes, what do you do? It's a question we all have to face. Do you legalize it or don't you? It's a hard question.
If you legalize it, it cheapens life, doesn't it?
Senator, what I worried about is the least amongst us in those circumstances.
The unprotected.
My concern is that when you have a cheap option and an expensive option, people who can't afford the expensive option, they're the ones who tend to get hurt. The disabled, the elderly, the weak, minorities.
Yeah.
So those were my concerns. I might be right and I might be wrong. History will tell. And if I'm right, great. And if I'm wrong, yelling and screaming about it won't make me any better at it. It won't make me right. It was a contribution, part of a debate, part of a discussion. And I hope it was a respectful and useful contribution that at least one senator has read. And otherwise, and up until about a month ago, I think primarily occupied a very dusty bookshelf somewhere in a law library.
You prefer wet flies or dry?
Dry.
Dry. I do too.
Happy to express my view on that.
Do you use a floating line or a sinking line?
Well, with the dry fly,
You have to
floating
use the dry, but you don't use wet flies with a sinking line to go off those.
Well,
big
I've
crabs?
been known to cheat once in a while, and the bead head might go on as a dropper underneath my dry.
Did you know President Obama at Harvard?
Senator, I knew him, not well. Our past, it was a big school.
Yeah. Was he one of those, like, front row guys that was always raising his hand, or did he kind of stay in the back row like I did and avoid eye contact with the professor so you wouldn't get called on? Or you don't have to answer that.
We were in different sections.
Oh, okay. All right. I just want to ask you one last one. It's about legislative intent. I've read where you've said that trying to discern legislative intent is a, quote, notoriously doubtful business, and I agree with that. I mean, legislators and congresspeople have a multitude of reasons for voting as they do. But that doesn't make it the search for legislative intent and looking at the legislative history. It may not be dispositive, but that doesn't make it useless. I mean, wouldn't you love to have a verbatim transcript of everything that was said at the, 1787 convention, 1789?
Senator, I respect very much what this body does. I hope my career, my body of work, reflects my respect for this institution. As a judge, I have to look at what's presented to me. And I look at everything that's presented to me. Everything that's presented to me. I read everything that's presented to me. And I have used legislative history from time to time. as you've seen, and I know you read a whole lot of my stuff. I do worry when I'm putting someone in prison, for example, or involved in a ruling involving their liberty in particular, about charging them with knowledge of what happens in a committee room or a statement that might be presented only on the floor by one individual, rather than by the law that has suffered through the process of compromise, bicameralism for both houses, and presentment and signature by the president, and goes in the law books. Hidden law can be a problem. I worry a little bit about that, particularly in the criminal context, Senator. It's a matter, again, of due process and fair notice. So those are the considerations that a judge, I think, always considers. What's fair in terms of due process and fair notice, at the same time being respectful of this institution and the hard work you do for the American people.
I don't know if you're a drinking man, but you may want to have a cocktail tonight. Just kind of relax. I'm done. Just don't drink vodka. Stay away from vodka for a while.
Senator, I'm going to hit the hay. Thank you very
You've
much.
never been to Russia, have you? I meant to ask that. No. Strike that. Strike that question.
I've never been to Russia.
Thank you, Judge.
Thank
you, Mr.
Senator.
Chairman.
Thank you.
Let's go home.